Namaskar, I'm Assistant Professor Kritika Dev from LJ School of Law. Today we'll be dealing with another set of sections under the heading facts which need not be proved. Till now we were talking about what can be proved, what is relevant, and today we'll be reading. You can say that this particular combination of sections are the exceptions to the general rule. Like here in evidence, everything is to be proved. For everything, we need to give evidence, right? In order to prove our case beyond any reasonable doubt, we need to give evidence for everything. But this, as a whole, you can take as the exception of this very general rule that for everything we need to give evidence. And here, when it comes to these things, facts which need not be proved. We did not prove these facts. Now, what will happen if we are not supposed to prove it? Then, how are they going to be proved by themselves? Let's have a look. So, here, as you can see on your screens, that when it comes to facts which need not be proved are mentioned under section 56, 57, and section 58 of Indian Evidence Act. So what is actually mentioned and what are the facts of which we need not give an evidence, we'll see under these respective sections. Now the first section is section 56. Facts judicially noticeable need not be proved. Right? No fact of which the court will take judicial notice need to be proved. So whatever facts of which the court has taken the judicial notice, they need not be proved again by the party because the court has already taken the judicial notice, right? So now section, that was about section 56. So when it comes to section 56, as we have seen that the facts of which the court can take judicial notice, they need not be proved. Now let's take a general fact, as it was stated by this Honorable Supreme Court also, that when it comes to the industry workers, it can be a judicial notice can be taken that many of them are illiterates. A general judicial notice. The court should not be under the assumption that everybody is literate when it comes to the worker class in an industry. Then the court has said that when it comes to the industrial laborers or workers, then a judicial notice can be taken that many of them are illiterates. So when the court has taken that judicial notice on that very note, the other party should not come up with an evidence to prove that some of them are illiterates or many of them are illiterates because the court had taken a judicial notice. So things which are of very obvious nature, the court has stated that the court can take judicial notices on those facts in order to reduce, of course, the number of cases and in order to reduce the burden of evidences or the number of evidences in a single case, right? Now let's see section 57 of Indian Evidence Act. These are the things, the points that we are going to see under this section are the points of which the court shall take the judicial notice. Here the court is not having an option. The court shall take the judicial notice of these points which are mentioned in front of you. Let me read the points one by one. They are very simple to understand. Laws in force in the territory of India, statutes, articles of war, proceeding of parliaments, accession and sign manner of the sovereign, seals, of course, every department has a seal. They shall take the judicial notice. Then there comes recognition of foreign states and their national flag. When it comes to the national flag, the court shall take the judicial notice that yes, this is the flag of that very nation. Nobody should come with an evidence that this flag is or belongs to that very state. The court shall take the judicial notice of these minor things, right? Division of time. What is the division of time? Territories. What is the territory of India? What is the territory of the other nation? These are the basic things of which the court shall take the judicial notice. Hostilities between India and the other state, whether we are in good terms or what terms are we in with the other nation, right? Names of the officers of the court, rules of the road when it comes to yellow, green, and red. What are these basic rules, right? The court shall take the judicial notice of these basic things. So the provision is the court shall, which means the court is not having an option whether to take it or not. The court court shall take the judicial notice of these things which we have read just right now. Okay, now let's move on to the next point, and in order to do that, let me adjust it. Okay, apologies for this technical thing. Okay, here is section 58 of Indian Evidence Act. Now what this section is trying to say, parties or their agents agree to admit. Here we are talking about the facts of which we need not give evidence, right? The court shall take the judicial notice, and once it is judicially noticeable, then we did not prove it. We had seen section 56 and 57. Now, what this section is trying to say is, if, of course, in a case there are two parties, again, let's take an example, party A and party B. Now, here the party A is trying to prove his point, and party B is trying to prove his, uh, of course, with the help of the evidence. Now, if A party, right, if A party is trying to prove something, but the same fact had been at the hearing is being admitted by the other party. A is trying to prove his points through the help of the evidences, and likewise. But now, if B admits the same at the hearing, if A has a contention that B has taken or B has borrowed rupees 50,000 from me, and this whole suit is related to that very, the fact and issue is whether B has taken 50,000 from A, and a fact and issue is the amount of 50,000 taken by B from A. Now B admits simply in the court, yes, I have taken 50,000. He did not prove anything. Now, this, of course, is a big example as an overall example. But now, as soon as B has admitted it, A has A did not prove this very fact because B had admitted the same. Now, the second one is by any writing before the hearing. If A wants to prove something which had already been admitted by writing before the hearing, of course, not during the hearing. The first point is during the hearing, but this point is before the hearing. Hearing had not been commenced till date, but the other party had admitted the same, but it has to be in writing. It cannot be through any other process, it has to be in writing. The 2 points which need to be kept in mind before the hearing, and second is it should be in writing. Only then, now the present party did not prove that very fact which had been already admitted by the other party in writing before the hearing. The, the third one and the last one is rules of pleading. Right? When it comes to pleading, it contains both plain and written statement, right? So if anything is being admitted in the plain or in the written statement, then the same is not required by the party to prove. The party did not prove that very fact because it had been there in the rules of pleading. The other party has either accepted the same, had been admitted the same uh, in the plain or in the written statement, right? So this is all about when it comes to what can be proved and what cannot be proved. So with this, I guess this you can take as section 56, 57, 58 as the general exception of the overall rule that for everything evidence has to be given. For everything you have to prove in the court. But when it comes to anything of which judicial notice can be taken, and section 58 admitted by the party at the hearing, before the hearing, or through the rule of pleading, then these things need not be proved. You're exempted from proving. You do not prove these very facts. So, with this, I would like to rest my lecture. I hope everything when it comes to section 56, 57, and 58, everything is clear. Now you would know that of what facts judicial notice can be taken. Right? With this, I would like to tell you, as I always say, uh, revise it again in the Bare Acts. Look into your Bare Acts once again. See these points, and always keep the Bare Acts and the notebooks with you when we are dealing with evidence. It is very important that you make the running notes in order to understand it. Right? Till then, you keep studying, as I always say, keep revising, and thank you so much for listening.